Baldoni's case is done and over. Updates to the case this week have exposed his entire defense was a lie. 16 YouTubers and 20 X accounts were informed that their account information had been subpoenaed by Blake Lively's legal team. These content creators then waived their subpoenas live on stream, arguing that this was a violation of their First Amendment rights, even though the government is not involved in this case. And how this was a massive fishing expedition, an abuse of power by Blake Lively herself to silence content creators who were critical of her. And now we know why those creators had their information subpoenaed. Baldoni's PR team identified those content creators as people who had provided content or services at the request of or on behalf of Wayfarer themselves. In August of 2024, it was revealed that Justin Baldoni had hired the PR crisis manager used by Johnny Depp, Melissa Nathan, and her firm, Tag. Lively's legal team then asked Tag to turn over the details of all content creators who had provided content or services, quote, directly or indirectly, at the request of or on behalf of any Wayfarer party or their agents or affiliates, having to resort to a motion to compel in order to force Tag to hand that list over. On Friday, we learned that they had turned that list over, and those 36 creator accounts that had had their information subpoenaed were all identified as either directly or indirectly providing content or services on behalf of Baldoni's PR team, proving that Baldoni's PR is still actively influencing content creators and their content in order to continue his smear campaign, despite Tag trying to claim that they stopped working for Wayfarer in September, which can't be true because many of these content creators didn't even cover this topic until months later in December. But then Tag falsely claimed this list was trade secrets and designated it attorney's eyes only, meaning Blake Lively's legal team couldn't even share it with Blake Lively herself, nor could they talk to the content creators themselves to explain why their account information was being requested. Lively's team are now asking the court to force Tag to remove the AEO designation, stating that it's ironic that Baldoni's team originally fought against the AEO designation, claiming Lively's team would abuse it to hide information, and now that is exactly what Baldoni's team are doing. But we're not done. Lively's team had also asked Tag for the list of journalists that it had contacted about either Lively, Reynolds, or the lawsuit from June 15th, 2024 through to the present. Again, Tag had fought against this and sought to limit this only until December 2024, which is when Blake Lively filed her lawsuit. Counsel for Tag employees, Maxwell Breed, also stated in a hearing that Tag's engagement with Wayfarer ended sometime in September. So there'd be no reason to provide any information past December since there wouldn't be any, right? Tag again lost that fight and the court compelled them to turn over the full list until the present, which they did, but in doing so, appear to have provided tampered evidence. First, what is significant is not who is on the list, but who is not. Most notably, Megan Twohey, one of the authors of the New York Times article, whom Wayfarer provided a joint statement, including Melissa Nathan to, as part of a response to the New York Times article and the CRD complaint. Also missing is Sarah Nathan, Melissa Nathan's sister, who works for the New York Post, who Baldoni's own documents show that Melissa Nathan was talking to and working on articles with. Such as this, where Melissa is sharing screenshots of her conversation with Sarah, and Sarah tells Melissa, so pass on whatever you need to put in and I will put it in the article she's writing. Another name missing is Lillian Gisson from the Daily Mail, who reached out to Wayfarer for comment in August, and Stephanie Jones was told to stand down and not respond to her because Melissa was going to handle it. Melissa Nathan also bragged openly about having talked to a female editor at the Daily Mail, again likely to be Lillian Gisson, but that female editor is missing from the list they provided. Now, many of the names that are on that list are not surprising, but two very much are. Both Ruth Stiles and Candace Owens did not cover this topic until after the New York Times article and CRD complaint in December. In fact, Candace Owens, in response to her own recent subpoena in this case, said, I have not the slightest idea what I'm being subpoenaed for, as I knew none of the respective parties when their lawsuit was filed. But if Owens and Stiles didn't cover this topic until December, why was Tag contacting them when supposedly their engagement with Wayfarer had already ended 3 months earlier? It appears Tag may not be telling the whole truth. And finally, we come to Jed Wallace, the PR crisis management expert who allegedly provided, quote, social media mitigation and proactive fan posting to counter the narrative. Now, in his own defense, Wallace swore under oath that to the extent any conspiracy to retaliate against Blake Lively for asking for workplace protections exists, he was completely unaware of it. Well, an unsealed email from this week showed that Tag had sent Wallace Lively's list of workplace protections that, as Wayfarer's own legal team acknowledge, were in response to Lively's concerns about workplace safety and professionalism on set, showing that not only was Wallace aware that Lively had engaged in a protected activity, but that his engagement with both Wayfarer and TAG was directly related to and in the context of that protected activity. Now, this information was shared with Wallace on August the 5th, which is 2 days before he was officially retained, showing not only was he aware, but it was being provided in the context of why he was being hired, and apparently not a deal breaker for him signing on. Now, as discovery comes to a close at the end of September, we'll move into orders about the indisputable facts of this case. We know from the evidence that is public so far, Lively did ask for and was granted workplace accommodations due to concerns about workplace safety, that Wayfarer did hire PR crisis firms directly to respond to those workplace accommodations, working with journalists both before and after the New York Times article went public in order to shape the narrative and plant stories, and even going so far as to engage with content creators either directly or indirectly in order for them to provide content and services for Wayfarer's benefit to again manipulate and control the narrative. There's almost no aspect at this point of Baldoni's defense that has survived document discovery, meaning there's a good chance after all those summary judgments are issued, there's little, if anything, Lively will need to prove at trial. Yet even when Baldoni inevitably loses this case, as the mountain of evidence collected by Lively's team confirms the consistent narrative and story she's held to for the last 7 months, there will still be an entire army of people unwilling to accept that they got this completely wrong, not recognizing that this is due to a culture that provides abusers with an unlimited and endless benefit of doubt that even facts and evidence are unlikely to dislodge.